This is an appeal in the matter of A1 and Secretary of State for the Home Department.
Good morning, Lawrence. I am
Yes.
Tom Tarbury.
Yes.
I'm here for the appellant, Secretary of
Yes.
State, and my friend psychologist for the respondent A1. Can I, before I get into a summary of facts, which I don't have to spend very long on, and then my second stage will be some submissions on the law, and then my third stage some submissions to development grounds, which will be one, another way of putting similar points. Can I, before all that, check you have what you should have, so housekeeping.
Yes, what we have is a bundle which runs to 252 pages.
Yep.
And we have a bundle of authorities which has, I think, been updated fairly regularly and recently.
550 page long?
Yes, I think that's right. I've got that in soft copy here, so let me just open it up. But yes, I think we have everything that we should have.
Great. The only further, and I'm sorry there is a further point, is about that evolving authorities bundle. I noticed that tab 2, the section 72 provision, is it's not the current, but it is nonetheless a later version than we are looking at. So we emailed in and I've handed up the contemporaneous version.
Yeah, we have that here. Thank you. That's the one
The
which we
difference-
consider. Yeah.
The difference is between the versions immaterial anyway, because the change was in relation to the first limb, namely particularly serious offence rather than our concern.
Yes.
So my introduction then is simply to say that the Secretary of State's appeal arises from her decision of the 8th of December 2022 to revoke A1's refugee status under Section 72 of the 2002 Act. The first tier allowed A1's appeal. The upper tier dismissed the Secretary of State's appeal there too, and the Secretary of State now appeals a second time to Your Lordship's Court. The question of A1's exclusion from the non-refoulement provisions of the Refugee Convention does not take place in the context of deportation proceedings, as is often the case, because his removal would be contrary to Article 3. So the practical difference of revocation would simply be removal of refugee status, which is of course real and different, because that might lead to settlement, whereas if Article 3 were the only barrier to removal, situation in Syria might change and deportation proceedings might begin at that stage. The offences for which A1 was convicted and that the Secretary of State considered were particularly serious crimes were the offences of encouraging terrorism and of disseminating a terrorist publication under sections 1 and 2 of the Terrorism Act 2006. He was sentenced to 2 years imprisonment for each offence to run concurrently rather. 2 years was the then threshold to trigger the first presumption, namely a particularly serious offence. Crime. And the Secretary of State appeals on 2 grounds, though as I say, the second is essentially to say that the upper tier didn't properly grapple with or determine the Secretary of State's submissions to them. And if you find rather on ground 1 that the first tier got it right substantively, then I accept that it doesn't matter that effectively that the upper tier didn't properly engage with our submissions to the contrary. That really is all I wanted to say as background, because you would have read my skeleton, etc. But
Yes.
There is, just to draw your attention to, a succinct chronology in the core bundle, the only bundle at 55. So to turn to stage 2, as it were, and the law. A lot of what I will have to say about the law I will address within my submissions, just because partly it's hard to be neutral on these points when we are contesting what they mean, so that's where the submissions belong. But also because hopefully that way you can see properly the application of these provisions and authorities. But some of the points of law can properly be put in this more neutral law stage. So the provision we're concerned with today, as I say, is section 72. But the starting point is Article 3 of the Refugee Convention. If I could just briefly ask you to turn to that, that's tab 1, page 4 of the authorities. You're not particularly familiar with, you may want to read 1 and 2 of 33 to yourself, but the key part is is in subparagraph 2, beginning with having been convicted. And that is the test, effectively, that is adopted by the immigration rules and that Section 72 interacts with. To turn then to Section 72, the version...
So just before you
Yes,
leave
of course.
the Refugee Convention, it may not matter, I don't know, but certainly my understanding of the way in which the arguments are presented on behalf of the respondent, there appears to be a suggestion that the person remains a refugee, therefore has the status of a refugee, even if paragraph 2 of Article 33 applies. And what this paragraph does is prevent paragraph 1 from applying.
Yes.
So the principle of non-refoulement doesn't apply.
Non-refoulement.
That may, could that matter, because you mentioned in opening your appeal that the reason why this appeal matters in practice is because it may affect things like the possibility of settlement. But I may have misunderstood the argument, but is it being suggested on behalf of the respondent that actually the other rights in the Refugee Convention would still apply? So someone would in principle be eligible for settlement in this country because he is a refugee.
But I take the point, certainly in 33 is concerned with refoulement rather than Article 1, the status. And 33.2 says the benefit of the present provision, so it's only concerned with refoulement rather than status. But it is the case that the decision giving rise to these appeals was, if I could take you to it, it's Core Bundle 233, a revocation decision. And that suggests at paragraphs 7 and 8 of the 234 that status impact is by operation of the rules rather than in Section 72, Article 33, non-refoulement exception.
Yeah, as I say, this may not be material
No, it's an
on
important
this
point.
appeal, but if the respondent does want to return to it, no doubt they can.
Then Section 72, just to have a look at that, because to an extent this is an appeal concerning statutory interpretation and the operation of this provision. So if you take up the hard copy version or the version emailed last night, but the correct version, 72.1 confirms the relationship with Article 3.2, we've just looked at. 72.2 contains the two presumptions, presumption as to having been convicted of a particularly serious crime and a presumption that the person constitutes a danger to the community. And both presumptions, you can see, are triggered by the same two conditions, namely being convicted of an offence in the UK and sentenced for at least 2 years.
Yes, on the face of it, and free of authority, you might have wished to argue that the word "and" in subsection 2 is conjunctive, not disjunctive. In other words, that there is only one presumption. But I think that was the argument the Secretary of State made in EN Serbia, but it was rejected. And that's binding authority on this court, at least. So you're not trying. I know you're not.
I'm certainly not going behind that.
revisiting that.
Relying on that.
So everyone to date, including the FTT, has proceeded on the understanding of the law that there are two presumptions,
Yes.
and you accept that.
Yes, I do recall in EN it being stated that you had to have a rebuttable presumption in relation to danger to the community. That bit had to be rebuttable, whereas the prior slightly different, a different approach to the extent where the way the law has now changed, it's not rebuttable, that first.
I see.
So they were treated differently, as you say, my lord, in that case, have now been treated differently in the way that legislation's evolved. And just from the approach you're suggesting of just first principles and reading it, I would not suggest that much as they're triggered by the same conditions, that they stand or fall together.
And certainly the way in which everyone, I think, has proceeded in this case is how the FTT directed itself. So it directed itself that there were those two issues
Yes.
it had to address.
Yes.
And in fact, it decided the first issue in your favour.
Exactly, yes. Yeah. In ways that we say bore far more on the second limb than
I see.
first tier appreciated. And then 72(3) to 5 are other categories by which an individual can be found to be a serious criminal, but that we're not looking at. We're only looking at that subparagraph 2. And then subparagraph 6 is the rebuttal ability. So we are concerned, as I say, just with that Lim 2 question, danger to the community of the United Kingdom. There are two authorities I want to look at within my law stage of submissions. First, the one we've referred to already, EN Serbia. This is at tab 10 of your authority, page 252. It's helpful to have some factual background. The head note on page 252 is useful. It says that they were made unsuccessful asylum claims before being granted leave to remain in the first case as a refugee. Subsequently, the claimant in the first case was convicted on 3 counts of burglary, 1 count of possession of an offensive weapon, for which he was sentenced to a total of 12 months detention in a young offenders institution. The claimant in the second case, convicted of wounding with intent, sentenced to 3 years. Served a deportation notice, appealed, Article 33(2) was engaged. This was a case in which a certificate was issued, so that's another of the categories under Section 72 that not engaged in this case, whereby a particular offence may be certified and therefore constitutes a particularly serious crime. The relevant parts, if we could just go straight to those, are paragraph 45, the first I wish to highlight, concerning danger to the community in our purposes. It's on page 274. What Justice Stanley Burton said. So far as danger to the community is concerned, the danger must be real, but if a person is convicted of a particularly serious crime, and there is a real risk of its repetition, he is likely to constitute a danger to the community. The second point I want to highlight from this case is at 66, which is on page 281. Between F and G, beginning in practice, His Lordship said, in practice, once the state has established that a person has been convicted of what is on the face of it a particularly serious crime, it will be for him to show either that it was not in fact particularly serious, because it's a first limb question, because of mitigating factors associated with its commission, or that because there is no danger of its repetition, he does not constitute a danger to the community. So I'm emphasising there that the mitigating factors element bears on that first limb question, for the obvious reason that we see in this case, in the sentencing remarks, that there may be mitigating factors going to how serious the offence should be considered to be, sort of backwards looking, rather than the future risk question. And then just to elaborate on, develop the point, the first of those 2 points, the paragraph 45, the real risk of its repetition question, so likelihood standard. We submit that useful guidance as to what real means in the context of risk comes from the extradition case Brown and Rwanda, decision of the Divisional Court at tab 8, page 137. Lord Justice Law's there in the paragraph beginning, the test is correctly stated. In the second sentence, real risk does not mean proof on the balance of probabilities, it means a risk which is substantial and not merely fanciful.
The test for what? What is he talking about in this paragraph?
I believe, my lord, he's talking about
Whether he'd get a fair trial in Rwanda.
yes. Yes, so paragraph 33, real risk of a flagrant denial of justice. So absolutely a different context. I suggest that this is, in terms of what real risk means as a standard of likelihood, that this is helpful guidance, but maybe it may not add anything.
I think that in this jurisdiction, in this country, when we're sitting in the criminal division of this court, we often come across concepts like risk to the community or danger to the community. And given that the background of this case is a criminal conviction and a criminal sentence, might that be a better context to look for guidance?
Well, first point I would say, my lord, is that I don't think that analogy helps in terms of any suggestion there might be a sort of different standard of proof, a more criminal one. Secondly, I would say that Brown is, to the extent that the criminal context is helpful to look at what real risk is seen to mean in the more criminal type context, helpful because it is in the extradition context. But really, I think I was suggesting simply that real risk has a particular meaning, as Lord Justice Law's says at 137 broadly, it's less than the balance of probabilities, is substantial and not really fanciful. But it may be that is trite. More helpful, I hope, is the very recent decision of this court in KD from March this year. That's tab 21, the last authority in your authorities bundle. This was a Section 72 case, like ours. Different facts, obviously. That was conviction for murder, but the same issue, namely danger to the community, and whether that presumption is rebutted. As in our case, the first tier had overturned the Secretary of State's revocation decision, and the first tier had been upheld by the upper tier before the Secretary of State appealed to the Court of Appeal. The ultimate outcome is the Court of Appeal allowing the Secretary of State's appeal. Can we start with paragraph 34 of Lord Justice Peter Jackson's judgment at 34, page 536. So you can see ground 2, dangerous to the community, it is our issue. Paragraph 35, the issue of dangerous to the community was therefore determinative of whether KD might qualify for protection from deportation under the convention. So just highlighting how much the issue there was our issue. Uh, 36 to 38 summarises the relevant convention provisions. Section 72. 39 alludes to the equivalent provisions in the immigration rules. 40 notably refers to that quote from 45 in the survey that I took your lordships to already. So this appeal is obviously handed down after our appeal in this case, but I would submit that a lot of the approach taken by Lord Justice Jackson supports what we say are the key issues, and in this instance a key part of the judgment in the Serbia, the real risk of repetition test. 41 quotes from the First-Tier Judgment in that case, and of course we're not looking at that for any sort of factual precedent, but there are notable factual findings there in terms of comparing with our facts when we look at them. So the tribunal there recorded and relied on the fact that KD had not reoffended, fully engaged with the probation service, met with them every month, was assessed as presenting as a low risk of committing further offences, and had undertaken rehabilitative courses in prison. (43, 44) was party submissions, and then at 45, acknowledges general principles in relation to appellate review, particularly in relation to factual findings and to a lesser extent evaluative questions. His Lordship says the judge making an assessment of risk in this or any other context undoubtedly enjoys a great deal of latitude, provided they sufficiently identify the main features of the evidence, weigh them up in a broadly coherent way. The assessment will be secure on appeal. And final sentence, I entirely agree this court should exercise restraint and not strain to fine errors of law. 46. Despite all of that, I've concluded that this decision of the first tier on this issue is not one that a reasonable decision maker could have come to. In accepting that KD had proved he was not a danger to the community, it demonstrably lost sight of a number of matters. 47. Submit this particular paragraph is a holding of law, if that's the right phrase, as to what, to assist you with another element of the correct approach. So the assessment of whether a person who has committed a particularly serious crime constitutes a danger to the community involves consideration of the nature of the crime, the likelihood of further serious offending, and the level of harm that might result. So we say that as a minimum, assessment, consideration of those elements must feature in the Lim 2 assessment for it to be lawful. And then at 48, His Lordship applies that and the real risk of repetition question. Passage cited at 41 shows that the first tier acknowledged the seriousness of KD's offence, but it immediately diluted that with statements that it was a single offence. Similarly, it gave no adequate consideration to the fact that the foreseeable consequences of reoffending were extremely serious. So we say that that is the case here too, because whilst it's not these weren't murder offences, encouraging terrorism and disseminating terrorist publications is similarly, to use Lord Justice Jackson's phrases, about the foreseeable consequences of any reoffending being extremely serious. So it's that It's that balance where risk is one part likelihood and another part severity. And if the severity is as great as terrorism attack being encouraged, then the degree of risk required being concomitantly low. And certainly requiring consideration and attention. He continued, most fundamentally, even after all remedial efforts on the part of Cambridge University to help him, there was still a real risk of repetition. The first tier did not depart from the assessments that he maintained a medium risk of serious harm to intimate partners, with a low likelihood of serious harm to everyone else. And then to 49. So in terms of risk to others, he said, as to the risk to others, the community should not be expected to tolerate a real likelihood of serious harm from individuals who qualify for deportation. And in this context, a low likelihood of serious harm is a real likelihood, in that it cannot be said to be fanciful. And then the last paragraph, I just want to highlight from.
It wasn't necessary for the court to go quite as far as to say that a low risk is a real likelihood, because actually the assessment in this case was that it was a medium risk of serious harm to intimate partners, which is obviously a real risk.
Yes, quite, absolutely. He goes beyond that and talks about the community and not just intimate partners. And I stress that bit because that's the relevant aspect for our index offences, if you like.
This is really why I asked the question I did a few minutes ago, because my lord will know much better than me. This is the language that one regularly sees in things like pre-sentence reports, when a criminal sentencing court is having to assess risks, for example, and the concept of dangerousness on offender. But again, I'll be corrected if I'm wrong, but I certainly don't recall seeing a context in which professional people will necessarily say there is no risk. That would be quite a strong, very, very strong statement to make. I mean, it is frequently couched in terms of high risk, medium risk, or low risk. But is it your submission that if that kind of report to the court says there is a low risk, that means that there is still a risk, and therefore, as a matter of law, the presumption has not been rebutted?
But what I would say, Will, is that there isn't a seamless or automatic translation between the criteria, methodology, etc., used by the probation services. So we will look at two extremism risk reports, one private report, Carleen Safri, and one from the probation service, and they don't speak in terms of low risk anyway. It's not like an OASIS report. It speaks in terms of the extent to which certain risk factors from the three columns of intent, engagement, and capability are present. And it talks about them being not present at all. So it doesn't just go to low. There is a floor, a seabed, if you like. And then there's partly present, and then there's strongly present. So that if you like, in this context, there is actually more read across. But I would say nonetheless, as I began by saying in my answer, that there is no, even if it were expert evidence concerned with low, medium, and high, and there were nothing below low, it would be for the tribunal judge to nonetheless assess, for their own purposes, whether, to use Lord Justice Jackson's language, there's a low likelihood, in terms of their own language, as a matter of common law, effectively. I think in EN itself, there's reference to, I mean, I think it's a statement that there should not be automatic read across from such reports. but that point may be, manuals may be willing to take that point as read. Ultimately, the tribunal is considering a particular statutory scheme, not policy scheme of how the probation service, say, or risk analysts assess risk. But yes, to come back to my final points to highlight in KD. Further on that same issue, His Lordship referred to MA Pakistan, in which a case where the applicant received, this is paragraph 50, sorry, page 539, we're back on. Applicant received a 3-year sentence for money laundering, was facing deportation, sought permission to appeal to this court from the rejection of his appeal by the upper tier, one of whose conclusions was that the Section 72 presumptions not displaced because he posed a real risk of committing further offences. He argued that the tribunal should not have gone behind. Oh, here we are. This is, I think, makes the point I was just looking for. He argued that the tribunal should not have gone behind the probation officer's assessment, which was that there was a 17% reoffending within 2 years. Roger Elias, with whom the other members of the court agreed, stated at 19, the tribunal was not bound by the probation service assessment. And he added that in any event, this is the important bit, a risk of 17% reoffending over a 2-year period is not, in my judgment, in the context of a deportation case, a matter which can be treated as insignificant. It is a good reason for supporting a decision to deport. And then 51, page 540, Justice Peter Jackson says, all assessments of dangerousness depend on their facts. In this case, the index offence and the feared harm were of such gravity that in order to displace the statutory presumption, KD would have had to show that the likelihood of future serious offending was so low that it could effectively be discounted. Now, as he says, depends on their facts, and I certainly could not rely on it as factual precedent when it's so different than its facts. What I say that this is important in demonstrating is that when assessing the extent of risk of repetition, the level of risk can be extremely low, where you are talking about offences with the capacity for very high harm, at least in the context of those offences, if not in all, because you are already talking about particularly serious offences that cross a particular threshold and not just real risk of repetition of shoplifting. So. And then whilst we're here, I just refer to 52 because it shows the outcome ultimately that I invite your lordships to reach and to enter. He stated, I would substitute a decision that Section 72 presumption has not been displaced and that KD is therefore not eligible for the protection of the Refugee Convention. And then you can see the end of the paragraph. They went on to consider Article 3, which is not an issue in this case.
I may have misunderstood your skeleton argument, but I had thought, possibly incorrectly, that if your appeal succeeds, you wanted us to remit to the FTT. Is that wrong?
I would, if it doesn't count as too procedurally unrigorous, to add this, that the lawful outcome, the lawful disposal, if you feel able on the face of the evidence, is to applying, particularly in light of KD, which was handed down after my skeleton, that you are able to say that it's so clear in light of not just Peter Jackson's elucidation of the relevant principles when considering real risk of repetition, that in this particular context, from the facts you're confronted with, that that's the appropriate outcome. If you think, no, actually what's missing is all the stage 2, limb 2 assessment that Mr. Tarbury says is decidedly missing, and it's important that it be considered afresh, then in the alternative, yes, remit.
All right, that's helpful. The other thing, can I ask you before we leave this judgment? It's clear from Lord Justice Peter Jackson's judgment that ultimately what the case turned on was this court's conclusion that the finding which the FTT had made, or the assessment which the FTT had made, was one that was not reasonably open to it.
Yes,
on the
different
evidence
ground of appeal,
on the
yes.
evidence before it, and once this court has reached that conclusion, which is a very strong conclusion,
Yes.
one can perhaps readily understand why it then doesn't remit. It simply
Yes.
substitutes its own.
It wasn't open to them.
Yeah, exactly.
Yeah, no, I appreciate that.
But in the present appeal,
Yes.
do you go so far as to submit that there was only one conclusion on the evidence before it, which was reasonably open to the FTT?
I do.
It's difficult when you've got three different people, the policeman, the psychologist, and the extremist man, who might be thought to be saying there's another conclusion, plus
Yes.
the FTT, plus the Upper Tribunal.
Yes, for purposes of what you should do, do you mean, my lord?
Yes.
Yes. No, I think it would take certainly perhaps more grappling, if that's the right word, by your lordships with the facts than you're perhaps comfortable with when this is, in terms of our grounds of appeal, about point of law and the application of a particular provision. But if you properly viewed, and I've taken you to these reports and so on, that is, and in light of the principles stated by Lord Justice Peter Jackson, I would submit that you are able to so find, notwithstanding those reports, which are saying quite different things in a different context. They're not purporting to determine the statutory question. So yeah, I would submit that you are able, but as I say, in the alternative, remit. So to turn to the last stage, as it were, already making good progress, it's only 11 and I'm on my submissions. And ground one, which is the bulk of those submissions. So broadly, so the ground of appeal is that the first tier erred in its application of section 72, 2 and 6, disregarded relevant considerations in so doing, and the upper tier failed to recognise the same. And the submissions in support of that are broadly fourfold. First, it concerns what is said on the face of the judgment. Paragraph 34 of the first tier's judgment, page 175. The first sentence, the refrain about attaching weight to the evidence, which does very little to actually look at what the evidence is saying. But anyway, in that first sentence, the attached weight to the evidence is referred to above, and we consider the evidence which we have attached weight is consistent in supporting a conclusion the appellant is at low risk of reoffending. And with KD ringing in our ears, not to mention EN and Brown, we submit that that is sufficient for real risk of repetition. It wasn't qualified by any statement as to when I say low risk, I mean as used by probation services, and nothing meaningfully materially can be below that, because that would be an error of law of itself, because that doesn't apply to this tribunal judge. It's simply a low risk of reoffending, and that is very clearly enough, not least in the context of terrorism offences.
Isn't there a difficulty in just taking one set of words out without looking? It's a label, and the question is, what were they trying to describe?
Yes.
And when they use that label, if you read the rest of it, it looks as if they're saying, we don't think he's going to do it again. That's what they mean.
Yes.
Not, we think there's a chance he's going to do it again, but on balance, it's not such a high chance. What they're really saying is, he knows now there are serious consequences, and we don't think he's going to do it.
Well, the first point has to be that's what they say, that's not what this judge says. And as I said, the judge doesn't say that I adopt that as hedged in by the particular meaning that they inflected by their usage of it. He's saying simply low risk. He doesn't say my reading of these reports is that in fact there's no risk, or it's negligible, or it's trivial. The judge adopts their own meaning, language, wording. Second point, it was just simply to say, when one looks at the reports themselves, we see that low risk is not clearly what's being said anyway, and when the judge says low risk, it means more than negligible, very much more than trivial. If you look at, for instance, to go ahead in my submissions to the extremism risk report from the probation service. So at section 4 of that report on 187 begins factors and circumstances contributing to the committal of the crimes, and begins with engagement factors, and then goes through various factors that clearly by expert and objective calculus are deemed to be relevant to determining risk. First is need to achieve justice and express a sense of injustice. That's an engagement factor. It's present to some extent. That's what it says. It doesn't say not present. The second on page 188. The second that is that for which a score is put in the headline is the need for identity and belonging. That's apparently an engagement factor, and that is strongly present. Then, sorry, did you want the page?
Sorry, this is about the
Yeah. Yes. Yes. And then in the next is need for status. That's present to some extent. The next is, then there is a not present one. The need for excitement, comradeship, and adventure. And then susceptibility to so there's a not present one after that. Need to dominate others. After that, susceptibility to indoctrination present to some extent. Political and moral motivation present. So the Lordship will be able to read through that and see that none is absent, save for a minority. Most are present to some extent. Some are strongly present.
You really need to go to 193. That's going through the checklist that I thought was in that document, the RG factors, 22 factors, and it's what he makes it out. Otherwise, you'll have situations, my Lord says, where you'll never, once you cross the 2-year threshold, which is great seriousness, be likely to rebut it, because you can never say never. And the fact he's done it once, there must have been reasons why he did it once.
Yes, well, absolutely. And to find that the clearly present risk at the time has diminished below the threshold to escape the second positive finding on the second limb, you have to find that these are no longer present. And what it says, for instance, on 193 under assessing risk and conclusions,
I mean, is the section 4 things that contributed to the crime, i.e. the things that existed at the crime? Or is it saying, I'll have to read it again, these are things that existed at the state of the crime and they still exist today, sort of octroi, therefore they're indicative of a risk of repetition?
They are about committal of crimes, but my point, my lord, is that absent, so unless it be said that by some sort of parallel finding that they are no longer strongly present, etc., by this, in terms of this evidence, and more importantly by the judge who had to find that, then they remain relevant.
Well, it's telling us what factors were present at the time of the offence which caused him to commit the offence, and I suppose somebody could do the exercise of asking whether those factors are still the same. But I thought that's what they were doing at 5, was working forward. Given what caused him to do this in the past, where are we going in the future? But maybe that's not the right way to read the document.
No, you're absolutely right, Will, that 5 is the present tense, if you like.
So if you forgive me for interrupting, but if you just take as an example, and what the correct approach should be in a minute, but if you just take the final paragraph in the text of paragraph 5, section 5, but above the recommendation,
Yes.
if one simply took one sentence out of context, which of course is not the right approach, but if one did, they say there is no evidence that he has any motivation to cause harm based on ideology, cause, or extremist group. It isn't the correct way to approach a report like this that it must be read fairly and as a whole.
Absolutely.
But that ultimately it's a question of assessment and judgment for the First-Tier Tribunal to make of it what it will when it pieces it together with other pieces of evidence, not taking it by itself.
Yes, no, absolutely. Within the
Yeah.
parameters
Yeah.
of the law, namely the statute and its meaning per
Yes.
KD, and read as a whole, which I agree is important, means that you must read 5 not in isolation, but rather with the context of the risk that was found, because we are talking about risk of repetition. So you have to identify first of all what was the original offence and what led to it, what factors contributed to it, and to identify whether they're now not present, in order that you can say, well, all these raft of factors that pushed into it are not here anymore. And as to that paragraph you take me to, Miller, no evidence any motivation to cause harm based on ideology, cause, or extremist group. That's just one possible motivator. And I think even in the original assessment of factors, so engagement factors, it wasn't said that he was in any particular group, or that it was said that it was managing his emotions resulting from the crimes perpetrated against his family. See page 187, first paragraph under 4.1. Emotional regulation, second paragraph there under.
I'm sorry, which page are you on?
Sorry, I'm on 187.
Yeah,
Back at
yeah,
first
that's right.
engagement factors.
Yeah. But the difficulty, speaking of myself, I'm having with this approach is that this might be said to be exactly the kind of forensic analysis of the details of underlying evidence which an appellate court is usually advised not to engage in, because as has often been said, we're island hopping. We are island hopping, and anyway, it's not our task, and nor was it the task of the Upper Tribunal to be getting stuck in the weeds of the underlying evidence. That is the task of the First-Tier Tribunal, and you're perfectly entitled to submit, as you do, that the First-Tier Tribunal erred in law. But speaking for myself only, I'm having some difficulty in following where this argument is helping us to understand
Yeah.
whether they erred in law.
Well, look, just to be clear and to reiterate, the first submission, if you like, under this ground, is about what the judge says on the face of their judgment, their finding of low risk. So for purposes of this, I have other points to make about what's disregarded, the approach that where limb 1, particularly serious crime rebuttal, is heavy with all the dangerous, scary, negative things, if you like, and none are revisited, noted, etc. for purposes of the future. So we have that. And there's a point about all that's disregarded on that front. So not to island hop at all. I'm not seeking to re-argue in the least. This first submission is simply to say, when the judge themselves says low risk.
The difficulty that I have with that is that that's a label, and it's now assumed huge importance because a different court, dealing with a different way of expressing itself, attached focus to that, and you have to read it all. They weren't saying, we bear in mind the words of Justice Peter Jackson, they hadn't even been uttered then, and this is low risk. You read the whole of it and they say, he's a committed family man, he did it because he wanted to get revenge for his father, and there are all sorts of these reasons. And what they really think is, we don't think, given this particular circumstance, that he's going to do it again. And I think it's a bit too much to attach such significance. They said that word, therefore, the presumption cannot have been rebutted. What do they mean when they use that phrase is the real question, I think.
Yes, I agree that it has to be what do they mean by that phrase, and I would submit that in its context, not least everything said by the judge themselves in the first part of the judgment, and what's said in the underlying reports, though I hesitate to get into them for fear of it appearing as though I'm re-arguing their meaning, that was sufficient. And I take the point about KD being of its own facts, but I do submit that the holdings by Lord Justice Peter Jackson in that case about low risk being sufficient, his lordship referring to other cases.
No risk in this judgment in the way that Lord Justice Peter Jackson was using it. But then you really do need to read paragraph 25, for example, where they say, PCW saying that there's no risks, and they say he's come out, he's settled down, he's gone with his family and so on. My quibble with you is trying to treat the use of the word low risk as if they were using it in the way that Lord Justice Peter Jackson has used it, and I'm not sure that's fair.
But without this judge, this tribunal judge, having seen the KD judgment, I submit that low risk, as used here, just reading it fairly as to what is meant, but by a judge who could have said there's zero risk, just as a matter of language, of en Serbia, of real risk of repetition. It doesn't say low as in less than real, it was open to the judge to find something less than low. They find low. I mean, it's being too benevolent a reading to say it's ultimately misinterpreting what the threshold is to find danger to the community and real risk. For the judge to have found that low risk didn't cross that threshold, and that doesn't involve any fairness, I hope, in how the judgment should be read.
And it's in paragraph 34, that's where they actually use the expression low risk of reoffending. Up on page 175. It's followed by the observation, we note in particular the appellant has been consistent and emphatic that he didn't realise what he was doing was a crime. He was convicted on his own plea of intentionally encouraging terrorism.
Yes.
Do they say how that squares with that observation.
Well, not here, in keeping with the absence of necessary consideration, but if one sees, for instance, on limb 1, so in 16, for instance, we find that this point is emphasised. So it's for 15, it's in the context of 15, which is talking about how the sentencing remarks referred to your support for Islamic State stems from the killing of your father and your brother-in-law. You are not, for example, of a mindset, as I find, to encourage directly an act or acts of terrorism in the UK, which, just to pause, is because he says he was unaware. It's not, it's by the by whether he sought to actively do that. The point is, as was recorded in the sentencing remarks, he posted this, it was viewed 90 times, it was liked 3 times. It's not about his intent and his sort of mindset and was of sort of limited relevance first time round. So the fact that he doesn't seek to do it, to encourage terrorism, he says now, is not a change. But then with 16, as I say, regarding risk of reoffending, so that's a limb 2 question. So not a limb 1 question, but anyway. Carleen Safri says that the appellant expresses remorse and acknowledged that his support of previous ISIS-related posts could have encouraged other individuals to support the post or further fuel ideologies. And CS reports that the appellant told her, "I didn't think about people seeing the video. He did not want to see it." The issue wasn't those who didn't want to see it, but anyone who should see it. Or even those who did want to see it and were seeking that sort of thing to further fuel their flames. And the judge says, that we find supports a finding that the appellant has not rebutted the first presumption. But the first presumption is just about the seriousness of the past offence. Yet that should have bore on risk of reoffending, which, as the judge says expressly, regarding risk of reoffending.
I see the problem that the paragraph is not a model of clarity, but are they saying anything more than he hadn't thought through what he was doing? He was so wound up, if you like, with the desire for vengeance for his father that he just didn't stop and think, what will other people do when they see this?
I feel like that adds quite a lot to it, my lord, really, because what he says, that's not what he says, and ultimately the judge finds that, doesn't say off the back of that, oh well, that's pretty strong mitigation, isn't it? It's not really a serious offence. You have, I find, in light of your not realising, rebutted that, because it was all, you have the mitigatory factor of not really knowing what you were doing. Rather, the judge says, as that supports a finding the appellant has not rebutted the first presumption.
Yeah, I understand that.
Yeah.
We switch then to the secondly, which is what we're talking about.
Yes.
The question is, how does paragraph 34 fit with 16 and in particular 17? I'm just trying to work out what they had in mind. And of course the offence is serious, and you can't rebut the seriousness of the offence by saying, well, I hadn't thought it through. But you might be able to rebut the danger when you say, well, I have now thought it through. I do know what's going to happen.
Yes.
I understand it now. And not only that, I've been in prison for 2 years, and the last thing I want to do is go back to prison again. So you can see, even if it's not well put,
Yes.
that there is a tie-in between his state of blissful ignorance when he encouraged people to do terrorism and what the position is now.
Yes, quite. Well, there is that. It is that combination, as I keep saying, of what was his position then, as analysed in detail by all those factors, and what's his state of mind now. So a bit like in a regulatory context, you might look at, is there insight, so that you can trust this individual sees where they went wrong, accepts fault, and can be trusted not to do it again. On the face of what the judge finds, that's not present. So, albeit it's all done within or recognised correctly, in the wrong place. So, if we look at paragraph 17.
Well, 17 is a difficult paragraph, yeah.
So the judge says, JSR gives some particulars of the nature of the crimes committed, emphasises the severity of those crimes with reference to the nature of the material the appellant disseminated to the internet. We note with concern the appellant's oral evidence, so that's in the present, that his crimes were not intentional, which is contrary to the JSR that we've set out above. So there's denial still, which doesn't help a finding that there is now de minimis risk. Further, in his witness statement, the appellant says he was not interested in the ideologies or values of Daesh. This, we find, is inconsistent with the JSR and with the National Probation Service Extremism Risk Report. We find, therefore, this is colossal, that the appellant has not acknowledged the intentionality of his risks or his support for Daesh. So, the first point, well, not the first point, it was going to be my second point about sort of presaged it quite a lot now, is that a lot of these findings aren't revisited as they should have been as the statute requires on link 2.
Well, your submission is this can't be a case of he's now understood the error of his ways. He knows he can't do this and he knows it's wrong and he won't do it again. Your submission is paragraph 17 is he still doesn't know what he's doing.
Absolutely.
He's lying about it.
Absolutely. And so to come back to the meaning of low risk, it must be at least inflected by what the judge himself says, particularly in this paragraph. A low risk that nonetheless spans what we see in paragraph 17 is not low in the negligible sense of some extrinsic methodology from the probation service that can't go lower than low, say. It's a very substantive and meaningful, non-negligible low, just based on the judge's own internal logic, reading the judgment as a whole, as we must. In fact, and this is why this appeal is put in terms of a misapplication of the statute rather than just a rationality or reason to say, it looks very much like had the judge properly appreciated how the statute applies and these factors bore on future risk, the judge themselves would have dismissed the appeal. Because it's very hard to see how those findings in 17 could support a different conclusion, which is also why we say it's open to you in light of the findings of the judge themselves, without having you having to remake anything factually, that you can find that, in fact, the Section 72 presumption is not rebutted. But that's the first submission on ground one, is that about what is apparent on the face of the judgment.
Is one way of putting that, encapsulating that submission, simply this, that there is an internal inconsistency between the FTT's conclusion on the first issue,
yes,
and its conclusion on the second issue?
It's either an inconsistency if low means, as my lord says, actually low really means nothing. But my submission, and that's in contradiction, so I gratefully adopt that as an alternative submission. My primary submission is that low is consistent with that, and by that means something which is substantively high enough to be real risk.
Thank you.
I don't know if that makes sense.
Yes, thank you.
Yeah. So the second submission, area of submissions, is that at 14 to 17, so we've had a look at these now, so don't need to necessarily spend much time on them, but the tribunal had regard to a number of considerations that were applicable properly to Lim 2, but which the first tier then failed to factor into its assessment on Lim 2. These included at 14, paragraph 14, page 170, what's set out about from the long quote from the JSR, in particular at the end of that paragraph. You do, in my judgment, have a mindset which is supportive of Islamic State, whatever your underlying motive may be. That's relevant because irrespective motive, I was just fueled by revenge and trauma even, that was seen by the sentencing judge as an aggravating feature, not a mitigating one, saying you just accidentally fell into this. Whatever brought you to it, it's a risk. You pose a risk. That should have been considered, we say, on Lim 2. Chiefly, as I say, with some comment as to whether that remains the case. Then second is 17, which we've just been addressing, the intent issue and the contradiction in his oral evidence that it was intentional. That should have weighed heavily on the Lim 2 questions, we say.
And his support of Daesh.
Yes.
I'm looking at the sentence which you emphasised a moment or two ago, in the middle of paragraph 17 on page 171. We find, therefore, that the appellant has not acknowledged the intentionality of his acts or his support of Daesh.
Yes.
And as I read it, and I know that we should never read anything out of context, but as I read it, that is not relating something only to do with the past. That is an up-to-date
Yes.
assessment by the tribunal.
Yes.
And some people might be forgiven for thinking that someone who is in this country and has not acknowledged his support of Daesh, at least arguably, is a danger to the community.
You think that would be a pretty easy one, having been through so much post-sentence courses, etc., in prison, and I mean, he's literally in an appeal where he's seeking to show that he doesn't present a risk, and even then, he's unable to demonstrate that kind of insight. That is a serious blockage, clearly, to the development, to the reduction in the risk present at the original date. And most importantly, for purposes of this ground of appeal, it was not considered on Lim 2, where it belonged, as a matter of future risk.
And Mr. Tarbury, could you just help me?
Yes.
I can understand all these arguments as forming part of a reasons challenge or a rationality challenge, but how do they fit into the error of law in construing Section 72?
Yes, well, I'm glad you raised that, genuinely, because I'm conscious that KD was perversity. Another case that I was going to just take you to briefly, TC, was reasons. I submit that the statute requires a particular approach. It is, as we began by looking at, containing two distinct presumptions. Hence, the tribunal divided it up into those two sections. There is a particular approach required, and we say that this isn't merely a question of the rationality of the outcome or procedural logical leaps, or it could be a quantity of reasoning. We could say on Lim 2, where is all the reasoning? But chiefly we say this is misapplication, if you like, of what this provision requires. But we do add on ground 1 disregard of relevant consideration, so we have effectively added an ancillary aspect there. I hope that helps clarify where we're coming
Thank you.
So TC, just as I mentioned it, we'll go to it now. This is tab 16 of the authorities, my lords, page 444. So it's a decision of the then president of the First-Tier Immigration Asylum Chamber and then president of the Upper Tier Immigration Asylum Chamber. And one of the issues concerned section 72, which begins at paragraph 28 on page 451. Paragraph 29. Whilst this ground should have been more clearly pleaded, we're satisfied that the essence of the ground is made out. First, to gave inadequate reasons for the conclusion that the comparative was dangerous to the community, given the nature and extent of the evidence available. This is not because the tribunal didn't say enough. The reasoning on this issue is detailed and takes up some 2 pages. It says at the end of the paragraph that the tribunal properly acknowledged that the risk of reoffending was low if the appellant continued to remain mentally well. And then at 31, we accept Miss Ahmed's submission that each of these reasons, so you'll see sub 30 is a quote of the reasons found for finding that the danger to the community presumption was rebutted. And then 31 is that the reasoning is one-sided, exclusively positive view of the evidence on risk, which needed to be explained by reference to all the evidence in order for the respondent to understand why she lost on this issue. Contrary to A, Mr. Gregory's report's not so unequivocal, rather Mr. Gregory predicts a low chance of reoffending. So this one-sidedness is effectively an example of a way in which the reasoning on limb 2 can be characterised. You effectively have almost a dividing up by our tribunal judge of negative factors arrayed on limb 1, particularly serious crime, and then most wholly positive factors on limb 2, almost as though the judge had never made any of those anterior findings. And here it's put in terms of proper reference to the relevant reports. It's clearer on our facts because it's reference to the judge's own findings. Third area of submissions, moving up forward, is a slightly discrete point, perhaps a similar way of putting the same, well, it is a similar way of putting the same error, as it all goes to my same overarching ground. And this is that the tribunal further misapplied section 72 when they treated limb 2 as the stage where mitigating features should be considered. See paragraph 15 on page 170 of the bundle.
Sorry, which paragraph?
15, my lord.
Yeah,
It appears twice, this phrase, page 170. Taking into account the mitigating features recited in the JSR, we find it correct, as they should. See again, EN Serbia, or Justice Stanley Burton says, when considering the first question, consider mitigating features when judging how serious the offence. but then says, we find that many of these mitigating features are more relevant to our consideration of the second presumption because they go to the character of the appellant. But that's not correct. Those are questions which weigh on the prior question. The judge continued, we take into account that the JSR include, I accept your support of the Islamic State stems from the killing of your father, your brother-in-law by a rival militant group, and that is a context for your offending which serves as some mitigation. You are not, for example, of a mindset as I find to encourage directly any acts of terrorism within the United Kingdom, recalling again that there were also in the JSR multiple references to the to A1's mindset, such as it's clear to me you had and evidently still have a mindset which is supportive of Islamic State.
I'm not sure how this helps you. For this reason, you seem to be saying, if I've understood you properly, that things they said were really relevant to Limb 2 should have been taken into account at Limb 1. But it doesn't matter, you won on Limb 1 anyway. All you're saying is you should have won, and you should have won even bigger.
No, sorry, I've not been clear enough. I'm saying that findings on Limb 1, or certainly matters stated on Limb 1, that mitigating features bear on Limb 2 is erroneous because, one, they bear on Limb 1, and two, it betrays what I hope is increasingly becoming clear, that the judge has treated Limb 2 almost as a repository of the positive findings. The mitigating features are separated from their proper context, namely weighing the seriousness of the past offence, and transported to the distinct question of future risk, which one is an inaccurate way of dealing with Limb 1, but as my lord says, I'm not having a go at Limb 1. What it does is it means that Limb 2 ends up carrying, if you like, positive factors that don't belong there, which then distort the Limb 2 assessment.
But the factors referred to that go to his character, as opposed to the seriousness of the offence, I take your point, they might go to both. So what? Because you won on Limb 1. But if they are relevant characters, it's again playing with words and labels to say, oh, they're mitigating. He's seen it as a repository of positive. No, what he's saying is these things, which the sentencing judge called mitigating factors, are matters to do with character, and we think that's more relevant to assessing danger because we look at whether the appellant's likely to be doing it again. And I just wonder whether there really is anything of substance rather than a wordplay.
Well, I hope I'm not putting it simply in terms of there's a sort of formal prohibition on treating mitigating features as unmentionable on the Limb 2 context. There is something, notwithstanding Ian Serbia saying that effectively.
Ian Serbia said you can't take them into account at Limb 2.
No, it says the proper place for them. So, but you have to think through what. So he says that. Why? Why is that? He says he refers. There's a reference in the judgment to having taken into account Ian Serbia. But why does he say, notwithstanding Lord Justice Stanley Burton's statement that mitigation goes to the first question, I find it goes to the latter? It's an incorrect approach, I'd say.
speaking for myself only, this appears to me to be at real risk of the kind of forensic analysis that has been deprecated at the appellate level. The reason is this, that it depends on what mitigation is being referred to. So some of it will potentially be relevant only to limb 1. Some of it may be relevant to both limbs, as it appears to me, because if it's, for example, mitigation which is nothing to do with the offence, but everything to do with the person, then it may well be relevant at limb 2,
Yes.
and certainly not only at limb 1. And I think that what they were really saying at paragraph 15 was something in your favour. What they were really saying was that various mitigation factors that you're relying on in limb 1 are actually, they're not saying exclusively, they're saying more relevant to our consideration of the second presumption, because they go to the character of the appellant. And so, eventually what they conclude is that you have not rebutted the presumption that the offence you committed is particularly serious. And I find that perfectly comprehensible as an analysis. And I've read what this court said in EM Serbia and in the other authorities you reminded us of. But I speaking for myself only, I think we just need to inject some realism and common sense into all of this and say, well, it's not necessarily always to be neatly dissected and put into particular pigeonholes.
Yes.
You do have to do a kind of holistic evaluation. And as my lord has said, you won on limb 1, and you lost on limb 2. And I can perfectly understand your submission that actually the logical conclusion, given all the factors that persuaded the tribunal to mean that you won on limb 1, that ought to have led to the same conclusion, and you ought to have won on limb 2. I can understand that submission. I'm not necessarily accepting it, but I can understand how you put that point. But I'm not sure that your sort of forensic analysis of paragraph 15 is necessarily going to help you get there.
Okay. I understand the point, my lords. Just to lastly, just clarify why I say that it's not mere overly forensic, gotcha, wrong language point. There is a genuine, going back to your almost first question, Lord, about do they sort of stand and fall together? We say that the proper construction of 72.2 and all the sort of overseas equivalents and certification equivalent is that they are very different questions. One is past and one is future. And mitigation goes to, we say, the seriousness of the offence for obvious reasons, and the weighing how serious was it. It's more serious and more aggravating, perhaps, if you don't have various sort of obvious mitigating factors, sort of plea and mitigation. But as my lord's point about pointing out the different sections in the extremism risk report, what is present at the time of the offence and explained it by way of mitigation, as we're talking about, or in terms of contributing risk factors, is a different exercise to looking at what are the present factors bearing on the distinct, separate, temporally separated questions. So if I'm right that mitigation, and as Lord Justice Stanley Burton says, mitigation bears on the prior, then
what he actually says, I looked it up whilst you were talking, mitigating factors associated with its commission. So it wasn't all mitigating factors in the way you have in a sentencing exercise. It's those things which we have used the label of mitigating factors, but they're things connected to the commission of the crime. You didn't do any harm, you changed your mind and you rang up and said, I know I said there was a bomb, I was lying. It's those sorts of things, the things that make the harm of the crime less serious. And there are other things that makes the wrongfulness of the person's actions less.
Yes. Yes.
And you can call both sets of things mitigating, but the one is looking at one thing, was it that harmful? The other is looking at something different. Is he a bad person who's going to do it again? And just using the label mitigating factors doesn't help.
No.
Unless you
You could perhaps use a different term. You could
be
use a
better,
different-
yeah.
Yes. Say he said,
Factors to do with seriousness of offence, factors to
Seriousness.
do with danger to the community. It would be much better to have done that, but we're all human.
yes.
That's what he's getting at when you read paragraph 66.
Yes. So, having identified, say, that there are these, for want of a better word, mitigatory factors that aren't enough to say that this was not a serious offence, it's not. It requires at least more reasoning that is present as to why, when they're not sufficient there, they become relevant on the future risk context. So even if they could belong in both places, despite more obviously, at least, belonging in the first question, it's not simply to say that's where they belong is we say a misapplication or a misunderstanding of what the test requires. But I'm sure I've said enough on that particular point. So the last of the four areas of submissions on this ground is to say that the tribunal, as well as what I've said already, lost sight of the key considerations for the danger to the community limb 2 evaluation, namely, as summarised by Lord Justice Peter Jackson and KD, the nature of the crime, the likelihood of further serious offending, and the level of harm that might result. Paragraph 47 of the key. In particular, due to the wrong approach that I've been seeking to show was the case, is present on the face of the judgment, the tribunal failed to address a number of considerations that were manifestly relevant, without consideration of which the statutory question cannot be considered to have been lawfully performed. The first of those that I want to highlight is what I've actually covered already. It's the point that I referred to in the extremism risk report, which found page 188 strongly present engagement factor, the need for identity and belonging, without any sort of follow-up to say no longer present. And secondly, strongly present transitional periods. That's on page 190, paragraph 411. Similarly, no finding that which was strongly present is no longer. And then, as I mentioned before, the present to some extent factors, which is the majority, with only 3 not present. Similarly, the intent factors within that report were found present to 3 were found present to some extent. In relation to that report, the tribunal said there's reference to concern regarding the level of the appellant's disclosure. But the conclusion is supportive that the appellant rebutted the second presumption. That is a finding that that's not a finding, a conclusion that he no longer posed such a danger. And as I said before, the fact that, so to refer to that conclusive paragraph that the judge refers to there, quote, there's no evidence that A1 has any motivation to cause harm based on an ideology, cause, or extremist group. He used his support for Daesh as a platform to meet his needs. Did this via social media rather than committing actual acts of violence. Just ruled out one of multiple motivations and intent factors. It wasn't in the least a finding that the multiple partly or strongly present factors no longer subsisted, or only to a low or negligible level. So effectively, it's a failure to have regard to the actual content of the report and the misreading of its conclusion. In the A1's own independent forensic psychologist report at 221, we see again, consistently with that probation report, or the other application of the same methodology, partly present 6 of the engagement factors, 4 of the intent factors. And that's just not noted by the tribunal, whose job it was to consider whether, having found the first presumption not rebutted, i.e. this was a serious offence, i.e. one that we cannot tolerate, Parliament prohibits me from tolerating real risk of repetition of, there's no consideration of whether that's all still present now. Or this is not present anymore because of X, or that is not present because of Y. The tribunal relied heavily on A1's family life, see paragraphs 20 to 21 and 25 to 27, concluding that the appellant is a committed family man, paragraph 32. The bottom of page 174, we find the evidence presents a consistent picture of the appellant as a committed family man. It's not said why that was a factor that could show that the risk that inherently must have at least subsisted at the time of the offence, because it happened, wouldn't happen again, or that there was only less than real risk of it happening again, because the sentencing reports are close to the same. So page 249, there are significant mitigating features. You are a family.
Do we know the date of the extremism risk report?
I think from internal reasoning, it appears that he's still serving
His sentence.
his sentence at the time when this is written. So that, and he was sentenced in 2017.
Mm-hmm.
So it's quite
29th of August 2023, page 194.
Oh.
That's the translation.
I
Doesn't
don't know
seem
what
to
the
be dated.
translation of. That's a translation of the next one, isn't it?
Yes, yeah, exactly.
What is the date? I had a bit of trouble understanding the sentence on page 193. There are a number of protective factors such as employment, presence in the family home, and activity that are currently unavailable on release. And I didn't quite understand what I thought that made me think that he was in prison when he wrote it. and that on release maybe he wouldn't have a job or financial security, but he would be in the family home unless the person writing this thought that there were some problems going back to his family. So I found that sentence just difficult to understand, and that and the date then made me want to know more about the report. You see my problem?
Yes, my learner may be able to assist as to what that's being referred to there. Just whilst we're on that page 193, just to revisit what we were discussing before regarding the significance of not appreciating the relevance of supporting Daesh or why they shouldn't be supported. The second paragraph, a similar point was noted by the author. He had resided in, and this may be what you're referring to, just saying that he had resided in the UK for approximately 18 months before committing this crime, which is sufficient time to understand the effect Daesh-inspired terrorism had on this country.
Sorry, which page is that?
That's on page 193, second paragraph under assessing risk.
Oh yes, thank you.
So just to move on to my next point in this area of the submissions of disregards, effectively. That was regarding evidence of A1's mental health that was, we say, highly relevant to the stability of his situation and whether he could be trusted not to reoffend, whether there was a real risk of repetition. The importance of that factor was underlined by the extremism risk report that we were just referring to at 6.3, page 210. Quote, his mental health was a key risk factor to offending, and without this risk factor, the likelihood of his offending previously having been committed is low. So, conversely, with that risk factor, the risk is more than low. And you have my submissions on why low is in this context already real risk. So mental health is a key risk factor. It is offending in the past and in the present. The tribunal had before it the 8th September 2023 report from A1's counsellor. Begins on page 223. And on page 225, in the paragraph beginning as Mr. Schaefer's therapist. You to read that paragraph to yourself.
Sorry, which paragraph?
The one beginning as A1's therapist, was what I'm deeply concerned.
Oh yes, thank you.
Relevant to this issue, the case TC that we looked at from the Upper Tribunal, tab 16, is relevant again. So that on page 444, so 452, paragraph 31. in that case, as I've read out previously, although you may wish to read, my lords, 31 to yourselves, an expert report predicted a low chance of reoffending if the appellant remained mentally well and continued to be intensely supported. And we effectively have a similar picture here, where it's said by the extremism risk report that mental health was a key relevant factor, and by A1's own forensics independent report, which begins at 195. Paragraph 6.3, page 210 of that independent report, similar point. His mental health is a key risk factor. So, what is missing from the First-Tier's judgment is a proper assessment of whether his mental health was still a risk factor in light of that evidence from.
Well, they do deal with it to 35 to some extent, don't they? Page 175.
Yes.
And they say halfway down that if we anticipate that despite mental issues, he's not reoffended, managed to approach his life after release in a positive way, and it said so do I. And then they go on to deal with the evidence of the AV and so on, and say that despite mental health problems, able to live in this way. Isn't that enough to deal with the mental health? I mean, well, you may or may not agree with it, but haven't they grappled with it?
Yes, I know. I see your point. I was just looking to see. I'm not sure. Not sure whether, again, a bit like the family man factor, that is new. Whether he was without treatment at index time, as it were.
What is your submission on mental health? The mental health
just that it's very clearly another of the relevant factors, and there was inadequate regard to whether it was still one, in particular in terms of whether there was a change of circumstances supportive of the finding that the
paragraph
previous risk
25,
factor.
they detail the therapy evidence. They say in paragraph 25 expressly what EMV and so on has done and the symptoms and everything else. And then, having noted that, they say what they say in paragraph 35. So what is your submission about the relevance of mental health in this case?
I think the therapist says that she's not allowed to give any evidence about diagnosis. She's a counsellor.
Mm.
And the psychologist doesn't give any diagnosis either, does she? Or have I missed something?
Just having a look.
It's I think it's on page 210
Thank you.
at the top, really. Although the psychologist administers a lot of psychometric testing, she doesn't really say what the result of all that is. But at the top of page 210, she says he started the journey towards addressing his mental health, which is positive, but he's still experiencing difficulty managing his mental health and is in need of specialist support.
Yes.
This has been recommended but has not yet been received. He's been prescribed medication, but he's encouraged to take it. And at the bottom of the page, that's where she says that his mental health was a key risk factor to offending.
Yes, exactly. So I'm grateful. So an overview. It was a risk factor. It's agreed from different sources. He was beginning a counselling journey, as we've just seen, so that is a change. But in the evidence before the tribunal, it perhaps comes closest to being medical evidence here, namely Alison Victor's letter / report from talking therapies, expresses real concern in this area. So the fact that she's accessing counselling and hasn't reoffended, to go back to what the judge says, is not to the extent of it. There's not a reference in paragraph 35 that his counsellor is really concerned about, never mind that he's accessing counselling. And that was a real risk factor, and it's seemingly still engaged, it's not gone away. Instead of referring to that real concern, the judge says at 35, significant point we find is that despite experiencing these issues, the appellant has not reoffended and has managed to approach his life after release from prison in a generally positive and active way. So the not reoffending is clearly, at best, a neutral factor, not least because during the relevant period he was still subject to sort of reporting restrictions. So he had to meet up with the policeman whose letters are before you, PC Downey, and see KD, where the fact that there being no reoffending was not seen to carry much weight. But the next point, has managed to approach his life after release from prison in a generally positive and active way, is not a point on mental health and precariousness at all. The next sentence, that was a family man, and then willingness to access treatment reflects the behaviours of a family man, because it's referring back to that sentence, and then willingness to take time off work when he needs to because of his mental health. I mean, there needed to be some reference to say so there is reference to be fair, to Alison Victor's letter, but what it says is the evidence of AMV and the less support from the appellant are all consistent and supportive of findings that despite mental health problems, the appellant is able to live in this way. And that supports the conclusion that the second presumption is rebutted. But as we've seen from that letter itself, it's not just saying he's living a peaceful, contented family life. She says as his therapist, I'm deeply concerned about his current state.
They do set that out expressly, paragraph 25. He quoted the second half of the paragraph. And they knew about that, and what they decided was, notwithstanding the concern that she'd expressed, for the reasons that they've given, what's actually happened, how he's returned to his family, and so on, he's coping, and that may or may not be adequate. But at the moment, I'm struggling because they've clearly had the evidence in mind, and they've looked at other factors which they think addresses that.
You have my submission.
Yeah, I've got the submission.
Moving on. In relation to PC Downey's answers, our submission is that there was failure to properly appreciate that his role was concerned with a different question to the statutory one that the judge was concerned with.
Can you please encapsulate for us, in a sentence or two, what that difference was, what that failure was?
So the so PC Downey's task was about monitoring compliance with anyone's compliance with Part 4 of the Counter-Terrorism Act 2008, and monitoring any changes which may affect his mindset and trigger any thoughts of reoffending, as the tribunal says at 20. But the tribunal's task was not about an absence of changes, it was about finding changes from a previous state of presumably high risk. So for PC Downey to say, I've been visiting him, his home's tidy, no signs of potential triggers, it didn't go very far to showing a change, which was essentially is the task on limb 2.
Are you saying that the evidence of his views and experiences was irrelevant to the tribunal's task?
Not irrelevant, but limited in as far as it went, and certainly no counterweight or not outweighing the tribunal's own findings under limb 1. So it's not enough simply to say the tribunal to say at 20 that they attach weight to PC Downey's answers. It had to be thought about what that actually meaningfully meant for the question before the judge themselves. For instance, it's not clear, and it's not said by, least of all by PC Downey, that none of those factors, a clean house, a family man, weren't present at the relevant time, because that's not PC Downey's concern. And the further relevant point is that to be behaving well, say, whilst you're having to have these visits, can only be of limited significance anyway, given that that is a period in which compliance is necessary. So I don't say that it's irrelevant evidence. I say that what's missing is an appreciation of those distinctions. So at the bottom of paragraph 20, bottom half, quotes from PC Downey. Appellant, since his release, has been fully compliant with the counter-terrorism policing officers. My impression is that he's hard-working, family-orientated and contrite. I find no signs of false compliance in my dealings with him. Been no further instance of crimes. He was working in his low risk of reoffending and being a danger to the community in the UK. Noticed his home was always clean, tidy and homely when he visited. He met his wife and children at 21. The reason why we attach weight to Mr. PC Downey's answers as follows. His answers are detailed and specific. He's a police officer who was responsible for monitoring the appellant. He had contact with the appellant 25 occasions.
They returned to this in a sentence, I think, in paragraph 35, page 175. In the middle of that paragraph, they said that we are satisfied that if PC Downey had considered that to have been signs of the appellant constituting a danger to the community of the UK, this would have featured in his answers to the questions that he was asked. In a nutshell, isn't that what they're deriving from PC Downey's evidence? That they're not saying it's conclusive, they're not saying his evidence is even necessarily the weightiest of all the evidence they're taking into account, but they do take it into account, they do attach weight to it, in a sense, for the negative proposition. Because, I mean, suppose he had said, I'm very concerned that this man poses a real danger to the community. Well, that might well have been, well, perhaps even decisive in their consideration.
Yes.
Isn't that all that's going on here in their reasoning?
Yes, I mean, if I am conceding that it's not irrelevant and therefore deserves some level of weight, then one can't criticise the judge saying I attach weight to it. But there has to be some sign for an evaluative exercise such as this. It's not simply saying I attach weight to that, I attach weight to that, I attach weight to that. There has to be some grappling with the fact that what's the context of that for what's being said. So were any of those things that, so the things that PC Downey says are, so no red flags, and a clean home and so on. And as I said before, unless that had been found in one of the sort of analyses of the risk factors as somehow being a problem, then the fact that there had been that change, as recorded by PC Downey, wouldn't be relevant. Was PC Downey able to see and consider any of the 24, say, risk factors? PC Downey doesn't look at intent factors, engagement factors, doesn't look at capability factors. So it really means nothing save to say he's not reoffended. He's not sort of brandishing intent to reoffend in front of me. So unless this really just becomes a sort of was nebulous, I attach weight to it and that's sufficient, I submit that a proper consideration of whether there is actual risk at the statutory standard does require identification of the extent to which it actually bears on the question. And simply saying he would have said it, if he considered there to be signs of risk, I'm sure he would have mentioned it. I mean, of course, but it doesn't go very far, really. Of course, if he had said it, that would have been striking. But the absence of it from a report that not particularly charged with considering change from the relevant time, namely the factors detailed in the sentencing remarks, doesn't go very far. And yet you can see that a great deal of weight is put on this. sum up, the proper application of the statutory question requires more than was performed in relation to that. So when I was in relation to the Upper Tribunal, those are the four areas of submissions in relation to the first tier. In terms of the upper tier, essentially the point is not to recognise those errors.
Yes,
And
you're really saying that the Upper Tribunal should have accepted the submissions which you're now making to us,
Quite.
and in not doing so, they made an error which entitles us to intervene.
Absolutely. So I don't think it particularly helps you for me to sort of point out where they got that wrong or belabour that point. And that really goes for ground two as well, just to say that we were trying to say this, but you have turned it all into a re-arguing the first instance, which we've very much avowedly, I hope that's clear, not seeking to do. So unless I can open any further.
Well, can I just be absolutely clear? Because it's my fault, I'm sure.
No, it won't.
But at times, and this may be why the Upper Tribunal said what it said, at times your submissions have been to the effect they fail to address a relevant question. That I can understand. That's an error of law. But at other times, but when it's pointed out to you by my lord, for example, that actually they did have regard to the evidence about mental health, paragraphs 25 and 35 and so on, then at times, certainly I've understood your submission as veering towards saying, oh, well, they didn't reason their case, their judgment sufficiently adequately. That's a reasons challenge, which isn't the same thing as an error of law. And at other times, I think you've gone so far as to say that they reached a conclusion which was not reasonably open to them. In other words, that's a perversity challenge. Can I just be absolutely clear before you sit down? Ground one being really the substantive ground before this court. In a nutshell, what is the Secretary of State's ground one? Is it that the FTT erred in law?
Yes.
Or that it inadequately reasoned its judgment? Or that it acted perversely? Which of those is it? Or is it all of them?
Well, it's certainly the former. We say that 72 to, in particular, its second presumption and its 72.6, the scope for rebutting it, requires a very different approach to the one taken by tribunal judge. First, in respect to the height of the threshold that makes rebuts the threshold, rebuts the presumption. Secondly, in terms of failure to consider relevant considerations by properly applying that Lim 2 question, by setting out various matters on the Lim 1 that aren't then considered as they had to be mandatorily, we say, on Lim 2. There's the point about mitigations, which again goes to a question of not of reasons or of perversity, but as to proper application of this particular test, this statutory test. And then lastly, what the proper application of the test would have involved regard to, namely matters that I've listed. And I take the point, my lord, that it's possible to say, you say you didn't consider mental health. Here are some paragraphs touching on mental health. The point nonetheless remains. It's not what was done with the regard. It remains a question of what's missing. So it's not enough simply to say he is attending his counselling. What is overlooked is the points I've highlighted. There is omission to consider what are surely mandatory considerations for purposes of risk. Namely, that this was a key risk factor, and the most recent mental health evidence shows real concern. And I see that you made the point about, well, that's quoted, but that's still not really regard, is it? Because it's not grappling with what that means. Test, that's why it's put in terms of what the test requires, because it's not just, we say that these obligations as a matter of law come from the statutory provision. And that's why it's put in those terms. I absolutely accept that there is effectively overlap in different ways, because I had a ground 3 saying the above reasons amount also to perhaps to common law, public law error in terms of disregard or in terms of inadequate reasons. As I said before, you could say not only is it a breach of section 272 to fail on the second limb to do X, Y, Z, but it is also, as a matter of public law, disregard of mandatory considerations. But we focused it solely on what the statute requires, not least because it is a very particular test for the reasons given in EN and KD. It's certainly not your fault for not having it. I couldn't have been far clearer the first time around. I hope that helps.
Thank you.
Thank you very much. Yes, Mr. Bandigani.
My lords, could I begin by asking you to look at page 174 of the bundle? This is the middle of the first tier decision, and it sets out the case that was put by the Secretary of State at the hearing. From paragraph 28 to 31. So I ask you to read that at the outset because I wish to make an important contextual point, which is that the appellant has been confronted throughout the course of his appeal against the decision to revoke his leave with a moving target. The Secretary of State's case, it's clear from those paragraphs and the remainder of the decision read as a whole, took no issue with any of the evidence that was before the tribunal, save to the limited extent referred to at paragraph 30 in relation to one piece of the evidence, and that's the psychologist's report, the CS report, which is then addressed later on in the decision. The Secretary of State at that hearing did not apply in advance or seek to adjourn the hearing in order to secure the attendance of any of these witnesses to subject them to cross-examination. The Secretary of State also didn't produce any evidence herself. The First-Tier Tribunal properly directed itself in law see paragraph 8 and 12 in particular. That's at 4 of the bundle, page 170. It considered the parties' respective submissions. It considered and weighed all the evidence, and it reached its ultimate conclusion that the appellant did not, on balance, pose a danger to the community of the UK. Now, the Secretary of State said at the Upper Tribunal, and is saying today before this court, that notwithstanding the way in which she put her case before the first tier, nonetheless, the judges, the panel in that appeal, perpetrated an error of law because it misapplied the correct approach to the statutory provisions of Section 72, and then seeks to make good that core submission by reference essentially to a forensic reading of this detailed decision by the first tier. Now, it's my submission that ground 1, in all its different forms, discloses no material error. The Secretary of State's challenge amounts in substance to disagreement and an attempt to re-argue the case, disagreement with the factual findings that we say were open to the tribunal, and an attempt to re-argue the case by descending into discrete parts of the material that was before the FTT, bringing them to the attention of the court and saying, well, where is it that the FTT dealt with this issue, by not only confronting it, not only treating it as relevant, not only attaching weight to it, but then explaining in some detail why it is a case that was never put to it should be rejected. Dealing specifically then with the first point under ground 1, Secretary of State submits that the tribunal's observation at paragraph 17, essentially 17, which is that the appellant has not acknowledged the intentionality of his acts or his support of Daesh, was not carried over into its assessment of the second presumption. My response is that is incorrect on a fair and proper reading of the decision as a whole. First, contrary to State's submission, the tribunal did carefully evaluate A1's evidence when looking at the question of the second presumption, and did pull through into that assessment its observations when looking at the first limb at paragraph 17. If I can ask you to look at paragraph 26, that's at page 173 of the bundle. The tribunal notes there that A1 provided a detailed statement, and it noted that it attached weight to it. It also held that A1's oral evidence reflected his written evidence, aspects of which concerned the tribunal, as my learned friend took you to, concerned the tribunal at paragraph 17. And if I can just ask you to go back to paragraph 17, you'll see 4 lines down, the tribunal notes with concern the appellant's oral evidence that his crimes were not intentional. Further, in his witness statement, the appellant says he was not interested in the ideologies or values of Daesh. So what's said there at 17, that's two parts of the appellant's evidence given orally and in writing. The tribunal at para 26.
The problem is they go on to make findings in 17.
Yeah.
As my lord points out, the two findings are, one, he's not acknowledged that what he did was intentional.
Yes.
But secondly, that he supports Daesh. He supports Daesh. And it's linking that with 34 that's
Yes.
the big question.
Yes. If I can just ask you then to go back to 26 for the moment, my lord. At 26, third sentence, we find his witness statement is consistent with other evidence in that he's provided a consistent narrative to third parties about what happened in Syria and the effect that this had on him in terms of it leading to his committing the offences. Goes on to say, we note consistency going back to a report by a consultant psychiatrist in 2017. And then there's a mention there of family life and employment history. Now, here, in the middle of the paragraph, it says, we found the appellant's oral evidence to reflect his written evidence. On many occasions, he repeated his narrative rather than answering the question that he'd been asked. It was explained to him that he should focus on questions asked, and the appellant did do this with some success for many of the questions. At times, the appellant's oral evidence displayed a fixed position as to his motivation to offend. And so if I can just ask you, just pause there. In my submission, the fixed position as to his motivation to offend means in substance that is in substance a criticism of the appellant's alleged failure to sufficiently address matters of intentionality and mindset, because he's completely fixated on the fact that the reason why he did what he did was to avenge the murder of his father and brother. So when you read 26, with 17, in my submission, they're talking about the same thing in substance. The tribunal go on to link the appellant's the fixed position adopted by the appellant in his evidence to what the tribunal said at 17 in relation to the first presumption. And it does that because it says, and, so after the sentence, at times the appellant's oral evidence displayed a fixed position as to his motivation to offend, and we have taken this into account, and the tribunal noted its significance in respect of the first presumption as set out above. So, what that means is that the tribunal is saying he's fixated about his motive, he's not addressing the things that are at least as important in his evidence. We take that into account. We note we've dealt with this under the assessment of the first limb as above. And that must be, in my submission, a reference to paragraph 16, which states, in the last sentence of 16, page 170, the appellant's own position shows that when he offended, he did not have in mind significant matters that made the offending particularly serious. And also 17, which begins with the observation, the appellant has maintained a consistent narrative about why he offended, we accept what the appellant experienced in Syria is consistent with his explanation of how he came to commit the crimes he did, and ends with the observation that in the appellant's evidence, this is the penultimate line of that paragraph, there is insufficient reference in his evidence to the fact he was convicted with because of intentional acts and was found to be of a mindset. So it's my submission that when the decision is read with anxious scrutiny or just carefully, and everything that the tribunal has said before is borne in mind, it's clear that the tribunal did, under the assessment of the second limb, refer back and link to that assessment or pull through what it said at paragraph 16 and 17, because those are the matters set out above in relation to limb 1. That's what it said that it did, and I've just shown you what those factors are. So the tribunal was fully aware that the appellant had maintained his actions were motivated by his particular circumstances, and those circumstances, the ones involving the murder of his close family members. It did not ignore that, and nor did it ignore the significant factors which the Secretary of State submitted today were incredibly important to the safety of this decision as a whole. In my submission, it's clear, either explicitly or reasonably implied, that this is exactly what the tribunal did, and I shall refer you, sorry, my lord.
There's still paragraph 34 as well.
Yeah.
And it follows that when they say in the second sentence, we note in particular that the appellant has been consistent and emphatic that he did not realise what he was doing was a crime, that he would not have done what he did if he'd realised that. One first thought was, well, that's inconsistent with 17, but you're saying, no, they know well aware of what the problem is. This is a man who's so obsessed by his revenge for his late father, his dead father, that he's just not facing up to it. It's not because he's going to go out and do Daesh tomorrow. He just
Precisely.
can't.
And this is my next point.
Yeah.
Yes. So
what they find in paragraph 17, is this right, is that he is actually, or was at the time when he committed the offence, for whatever reason, a supporter of Daesh. Now, if that's true, that's pretty relevant to the risk he poses to the community. So what you might be looking for is, okay, if he's no longer a supporter of Daesh, when exactly did that happen and how did it happen?
I think one of the...
Please
I take the point, my lord, I understand, but I think one of the difficulties with this case and the way that the appellant's case has been put is that it's looking for incredibly neat, tight categorizations of the evidence in a way that would perhaps logically make sense if a human being was not undertaking this evaluative judgment of another human being. And the relevance of that is that this is an individual who's been through incredible trauma over a long period of time, still suffers from serious mental ill health. And one of the points I'm going to make, in addition to the one raised by my Lord Justice Lewis, is that there's a cumulative form of reasoning or mode of reasoning here that when it's all carefully considered, as opposed to segregated, interrogated in isolation, which is what I say the Secretary of State's case is, you have a perfectly rational, reasonable, reasoned decision that was made in perfect conformity with the correct understanding of the law, and that this court should resist the temptation to rewrite this decision in the way that either the Secretary of State would have liked to have seen it, or that any of us might have written it.
So to come back to 17 again,
Yes.
I could understand the sort of argument that says, I didn't care who Daesh was. All I knew was they hated the men who killed my father,
Yes.
and he can't get beyond that. I can understand that kind of reasoning. But what it says further up in paragraph 17, the appellant says that he was not interested in the ideologies or values of Daesh, i.e. he wasn't interested in what they believed, and that would go with his fixation for, I want somebody to revenge my father's death. But they go on to say that that's inconsistent. And he does support Daesh. When you read it as a whole, it's not he's supporting Daesh because all he can think about is revenge. It is connected with, there is an element of support for Daesh's ideologies and values. True it is that in his mind they're the vehicle for retribution, but also they're a vehicle for retribution because they're a group whose ideology and value he supports. And if that's the case, that's got to be addressed, hasn't it? Because it is so crucial.
Yes. My submission is that it was considered and treated, the word used is significant at paragraph 26. It's a significant matter. It was pulled through. But if I perhaps can just address you quickly before the break, this way, I was going to go on to say that what the tribunal have in effect done, in substance, on a fair reading, is to balance and attach significance to other aspects of the appellant's evidence. So we have the primary finding, very detailed witness statement. We attach weight to it. We note that you haven't quite addressed these two issues, significant though they are. But we also look at what else you say in your evidence, and what you say is, do touch on the issue of risk, and they are that the appellant's consistent position is that he did not appreciate that his conduct constituted criminal offending. Now, that's not inconsistent with the fact that he pleaded guilty once charged with the offence and confronted with the material and on advice, pleaded guilty. What's essentially being said there was that at the time he was posting things on Facebook, he didn't appreciate that what he was doing was a crime. Subsequently, of course, he was confronted with the fact that it was, and that he could do no more other than plead guilty, which is what he did.
I thought he wanted to say it was reckless, not intentional, and so on.
I think that was canvassed or advanced, and then it was withdrawn very quickly. So the judge didn't attach any weight to.
Well, the judge sentenced on the basis that he intended
Yes,
to
of course.
encourage, and indeed, if he wasn't intending to encourage Daesh to perpetrate acts of terrorism against the people he blamed for killing his father, he wouldn't be seeking revenge, would he?
I accept that he pleaded guilty to intending to encourage Daesh to commit acts of violence against the other group in the armed conflict in Syria
Exactly.
who had killed his father and brother. We accept that. But my point is that it's not inconsistent with him also saying, when I was posting this stuff in a fit of anger and upset, feeling isolated, I didn't realise that I was committing a crime in the UK. And that's not inconsistent.
If he's got to rebut the presumption, there is a presumption that he's a danger. That arises out of commitment or support or a degree of identification with Daesh. He's not accepted, he's got an identification with Daesh.
Well, it's not just him saying this, as I'll go on to.
How can he then say, I've rebutted the presumption, I haven't addressed this, I'm fixated on revenge, I haven't addressed this, I'm not accepting it. How then can he have rebutted the presumption?
I think there are two broad ways that he does. One is what else he says in his evidence and what conclusions the tribunal reach about the likelihood or risk of him committing any crime again. And then secondly, there is the cumulative effect of all the other evidence, including some expert evidence, which in the round taken together permits the tribunal to do what it did. If the tribunal had, I think the key point at this stage is for me that if the tribunal had not said what it did at 26 about pulling through the significance of the shortcomings in his evidence, then it would be incredibly difficult for me to resist the appeal on the basis that that's not a failure to take into account material relevant consideration when applying Section 72. But my case is that it was taken into account, and I go on, and I will go on to show you the way in which the tribunal lawfully reasoned its ultimate conclusion that the danger was rebutted.
Thank you. Thank you very much. Very well. We'll break there and resume at 2 o'clock, please. Thank you.
All rise in favour.